In this lesson, we're going to spend some time talking about one of the most common features relating to the grounds for judicial review. And it's in fact a feature of English law that you will be familiar with if you looked at other areas and studied other areas, because it sort of extends into different zones and different parts of the law. And this is, of course, the idea of Wednesbury unreasonableness. Now, we're moving on away from illegality as a ground for judicial review. The previous lessons talked about the idea of illegality, the concept of the ultra vires doctrine, the idea of jurisdictional errors, the concept of relevant or irrelevant considerations, etc., etc., etc. This lesson is going to start talking about irrationality as a grounds for judicial review cases. Now, irrationality is slightly different, and one of the things that we have to think about in relation to irrationality is a conversation about the idea of Wednesbury unreasonableness as being a standard that is essentially tested by the courts in relation to this area. So, even though we are going to be talking over the next 3, 4, 5-ish lessons about the concept of irrationality, this lesson is going to be focused almost entirely on the concept of Wednesbury unreasonableness. Okay? Essentially, according to this principle, we can assess the validity of a public body decision. So remember, that's what judicial review is essentially instructing us to be able to do. We can assess the validity of public body decisions through bringing a judicial review case. In fact, you do so because you have no other alternative when it comes to judicial review cases. If you bring a public authority in through normal civil litigation, in fact, the courts don't take that particularly well. They argue that if it is under the remit of judicial review, it should be brought under that remit. Anyway, so we can assess the validity of a public body decision according to this principle by ascertaining whether or not the decision was reasonable. So it's sort of a way of translating the idea of irrationality to the idea of reasonableness, and sort of instead of trying to determine and making delineation between reasonability and irrationality in terms of the law, we basically just say that irrationality can be understood in a way that is encompassing of this idea of reasonableness. Now, a decision is considered to be unreasonable, specifically Wednesbury unreasonable, and therefore, as a result of that, considered irrational, if no reasonable person acting reasonably could have made it. So, the principle of Wednesbury unreasonableness is essentially one in which a reasonable person acting reasonably could not have made that decision. Not that they might not have made that decision, but something is considered to be Wednesbury unreasonable if a reasonable person, it would be impossible for a reasonable person to have made that decision, have come to that conclusion. It all dates back to a case from 1948, the Associated Provincial Picture Houses Limited case versus the Wednesbury Corporation. The facts of this case concerned the empowerment to grant licenses by the Wednesbury Corporation for the issuance of what was known at the time as Sunday entertainment. Remember, this is just after the Second World War, so things weren't that entertaining, really. So they had this idea of Sunday entertainment. One such license was granted to a movie theatre. The claimants were the Movie Theatre Corporation, the Associated Provincial Picture Houses Limited. One of the conditions of the license was that no children under the age of 15 were permitted on Sundays for the entertainment. Now, this decision was challenged on the basis that it was irrational, and as a result of which it was unreasonable. The question for the courts was whether the decision was reasonable or not reasonable. They held that it was reasonable, and it was therefore not irrational, and therefore the case was dismissed. There was no ground for judicial review in this case. However, really the outcome of this case isn't particularly relevant to us. What's more relevant is this idea of Wednesbury unreasonableness. The court considered that determining whether a decision was reasonable can be made on two different grounds. The first of these grounds was a test known as a test relating to improper purpose. The test of improper purpose essentially considered that a decision would be unreasonable if it is made either for bad faith reasons or considers irrelevant matters in the case. both of those reasons, both of those ideas would therefore show that there was an improper purpose. So the idea of improper purpose is encapsulated into two potential strands, the first being, of course, bad faith, and then the second being, of course, consideration of irrelevant matters. The second ground for which a decision can be understood as unreasonable is the idea of Wednesbury unreasonableness, i.e. that if an action is so unreasonable that a person who is reasonable could never make that decision, then it is considered to be Wednesbury unreasonable. On the facts, it was determined that the first test was inappropriate for the conclusion of reasonableness, and so they applied the case of Wednesbury unreasonableness. And they said that it was determined that a decision to ban under 15s in theatres for Sunday entertainment fell far, 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 far below the standard that is required for this particular test. Now, one of the things that should be noted here is that it is quite a high standard, okay? It sounds quite counterintuitive. In fact, it sounds relatively tautological to say that, okay, according to Wednesbury unreasonableness, something is unreasonable if a reasonable person wouldn't reasonably have made it. That sounds just like nonsense. But fundamentally, the point is that not that they wouldn't reasonably have made it, it's that they could never have made it if they were reasonable. A reasonable person could not have ever made that decision. That's what Wednesbury unreasonableness tells us. In application of this principle, we can look at the case of R&O versus Hammersmith and Fulham LBC. What this case does is illustrate the standard which is required to show an instance of Wednesbury unreasonableness and therefore an instance of irrationality. So note here that I just mentioned previously that there is quite a high standard. This case illustrates just how high that standard actually is. It was a case which involved the disagreement pertaining to two choices, okay? The choices were relating to an individual, a child, O, with severe learning difficulties, and where that child ought to live and where they ought to go to school. Since O was a child with severe learning difficulties, they fell under the remit of the Children Act from 1989, specifically Section 20 of the Children Act, which gave the local authority a duty for accommodation to be provided for him. Now, there was a disagreement between the local council on the one hand and the parents of the child on the other, specifically in relation to where O, like I said, should go and live and where they should go to school. Note, by the way, that one of the things that is often misunderstood when talking about cases involving children is that when it comes to cases involving children, the influence and interests of the parents are not as important as the best interests of the child principle. This is a fundamentally codified principle of English child law, even of international child law, if you look at the UN Convention on the Rights of the Child, for example. When the parents sought a judicial review case in relation to the local authority's decision to allow O to live somewhere else that they didn't want them to live, the question of Wednesbury unreasonableness came up. The court concluded that there was nothing irrational about the decision of the local authority to decide in the way that it did. They did not see any irrationality or unreasonableness in making the decision that they made. And they said here, quote, "Where a local authority simply chooses one way of meeting a child's needs rather than another, it cannot be said to have interfered with the exercise by the child or the parents of their right." Simple, really. It wasn't a disagreement about if you send my child here that they will essentially not they will not be able to live and develop and go to school in the way that is required as a standard for the legislation. Fundamentally, the duty of care to this child under Section 20 of the Child Act, or the Children Act, sorry, fundamentally requires that, of course, you have a duty of care to make sure that they live and go to a good school and are in a good place. That wasn't the disagreement. The disagreement was just where that child should live. Both of these alternatives could have theoretically been satisfactory for the child, and so as a result of which, it cannot be said that simply choosing one over the other on the basis of the child's needs falls outside of the remit of the local authority in the legislation, and as a result of that, therefore falls below the standard of rationality. And so as a result, that judicial review case was dismissed.